undue delay, waste of time, or being needlessly cumulative, just repeating evidence you already have.
So the judge is balancing how helpful the evidence is against these potential problems, with a thumb on the scale favoring admission.
A very good summary. It's a practical managerial rule for the judge.
What about when relevance depends on another fact being true? Conditional relevance.
Right. Rule 104. Sometimes the relevance of piece A depends on fact B being true. If relevance depends on a fact, sufficient proof must be introduced to support a finding that the fact exists.
Like the relevance of Alex's statement on a recording depends on proving the voice is Alex's.
Perfect example. You need that foundational fact. But, practically speaking, the court may admit the evidence on the condition that the proof of the foundational fact is introduced later.
Ah, so you can play the recording and then have the voice ID witness testify later.
Yes, it allows for a more fluid presentation, but that foundational proof must eventually come in, or the conditionally admitted evidence might be stricken. It's about logical prerequisites, but with some procedural flexibility.
Got it. Allows for better trial flow. Okay, now for a really big, often tricky area, character evidence. Rule 404. This seems like something that could be highly prejudicial.
It absolutely is, which is why the rules are so strict. This is a huge bar exam topic full of nuances. Character evidence is, generalized info about someone's traits: honest, violent, reckless. The general rule, the big one, is that character evidence is inadmissible to prove that a person acted in conformity with that character on a particular occasion.
The propensity rule.
Exactly. The law doesn't want the jury thinking, well, Alex has a reputation for being aggressive, so he must have committed this assault. That's using character to prove conduct on a specific occasion, and it's generally forbidden. It risks conviction based on reputation, not specific actions.
Okay, so that's the baseline. No propensity evidence. How does this play out differently in civil versus criminal cases?
In civil cases, the propensity rule is very strong. Character evidence cannot be used to prove conduct. Evidence that someone is a reckless driver generally can't prove they drove recklessly in this accident.
But there are exceptions.
Yes, when character is an essential element of a claim or defense. Here, character isn't showing propensity, it is the issue.
Like what?
Think defamation. The plaintiff's character or reputation is directly at issue. Negligent hiring or entrustment, the character of the person hired or entrusted, for example, their history of recklessness or violence, is central to the claim against the employer or owner. Or, child custody cases, a parent's character is directly relevant to their fitness.
So in those specific situations, character is the core legal question, not just a shortcut to proving behavior.
Precisely. Also, remember, character evidence is admissible for impeachment in civil cases, to attack credibility, like showing untruthfulness. And there are specific rules for civil cases involving sexual misconduct, though often governed by rape shield principles similar to criminal law.
Okay, now criminal cases. This seems even more complex, especially with the defendant's character.
It is. The prosecution cannot introduce evidence of a defendant's bad character just to prove propensity. He's a bad guy, so he did it. That's out.
But the defendant gets the mercy rule. They can choose to bring it up first, right? Open the door.
Exactly. Under the mercy rule, the defendant can introduce evidence of their own pertinent good character, usually reputation or opinion testimony. In Alex's assault case, he could offer testimony that he has a character for peacefulness.
But that's a strategic risk.
A huge risk. Because if the defendant opens the door with evidence of their good character, the prosecution can then rebut with evidence of the defendant's bad character for that same trait. Alex claims peacefulness. The prosecution can now bring evidence of his violence.
Okay. What about the victim's character?
The defendant may introduce evidence, reputation, or opinion regarding the victim's character when it's relevant to a defense. The classic example is self-defense. The defendant might offer evidence of the victim's aggressive character to show the victim was the first aggressor.
But again, if the defendant does that...
If the defendant attacks the victim's character, the prosecution can rebut in two ways. Offer evidence of the victim's good character for that same trait, peacefulness, or offer evidence of the defendant's bad character for that same trait, violence.
So attacking the victim can boomerang back onto the defendant's own character.
It absolutely can. And a critical note. In cases involving sexual misconduct, evidence of a victim's sexual behavior or predisposition is generally inadmissible under the rape shield rule, Rule 412. That prevents defenses based on irrelevant past sexual history.
That's a vital protection. So this whole character evidence dance in criminal cases really depends on who makes the first move. The defendant controls whether their own character or the victim's character for certain traits comes into play initially.
It's a strategic chess match, exactly. And remember, character evidence can always be used for impeachment, attacking any witness's character for truthfulness.
Okay, moving from general character to specific acts, especially prior bad acts, Rule 404B. These seem even more dangerous in terms of prejudice.
They are, which is why the rules are even tighter, particularly in criminal cases. Let's start with civil cases. When character evidence is admissible in a civil case, because it's an essential element, it can be proved by reputation, opinion, or specific acts.
So in that negligent entrustment case, you could bring in specific examples of the driver's past reckless acts.
Correct. But in criminal cases, it's different. When character evidence is admissible, like when the defendant opens the door, it generally may not be proved by specific acts. Only reputation or opinion testimony is allowed for proving general character.
So Alex can't say, "Here 5 times I walked away from a fight," to prove his peaceful character.
Generally, no. That would be specific acts to prove character for propensity, which is usually barred. The main way specific acts get into a criminal case is through the exceptions for non-propensity purposes. This is the huge Rule 404B exception, often called the IMIC rule.
Right. M-I-EEK. Let's break that down. Specific acts are okay if not offered to show the person just is that way.
Exactly. They're admissible when used for a purpose other than proving the defendant acted in conformity with their character. The purposes include motive. Why did Alex commit the assault? Maybe a prior dispute or debt involving the victim. Evidence of that prior act shows motive. Intent. To establish the required mental state or negate a claim of accident. If Alex claims the hit was accidental, prior similar intentional acts might show intent here. Absence of mistake, similar to intent. Negating accident. If Alex claims he accidentally injured the victim in a specific way, evidence he injured someone else the exact same way previously might show it wasn't a mistake. Identity. This is the modus operandi or signature crime idea. If the assault was committed in a very unique, specific way that matches Alex's prior crimes, that prior act can prove identity, common plan or scheme, to show preparation or a larger plan involving this crime and other acts, common plan or scheme, and there are others like knowledge, opportunity, preparation, consciousness of guilt.
So the prosecution has to articulate a specific, non-propensity reason for offering the prior act evidence. It's about why this specific act is relevant beyond just showing Alex is that kind of guy.
Precisely. And there's a crucial notice requirement for the prosecution in criminal cases. They must provide reasonable written notice before trial of their intent to offer 404B specific acts evidence, articulating the specific non-propensity purpose. This allows the defense to prepare. The court can excuse this for good cause, but notice is the standard.
Okay, what about using specific acts during the cross-examination of a character witness?
Right, Rule 405A. On cross-examination of a witness who has testified about someone's character, for example, Alex is peaceful, the court may allow inquiry into relevant specific acts committed by the person whose character is at issue, Alex.
So you can ask the witness, "Have you heard Alex was arrested for assault last year?"
Yes, you can ask, "Have you heard?" or "Did you know?" The purpose isn't to prove Alex was arrested, but to test the character witness's knowledge and the basis for their opinion. Are they really familiar with Alex's reputation or character if they didn't know about this relevant specific instance?
It challenges the foundation of their character testimony.
Exactly. But here's the limitation we touched on before. If the character witness denies knowledge of the specific act, no, I never heard that, extrinsic evidence is not admissible to prove the act occurred. You can't bring in the police report to contradict them.
You're stuck with the answer.
You're stuck with the answer on that specific point for impeaching the character witness's basis. It prevents many trials about every past alleged act. The focus stays on the witness's credibility and knowledge base.
Okay, let's distinguish character from habit. Rule 406. You said habit evidence is different and more admissible.
Yes, fundamentally different and generally more admissible because it's seen as more predictive of behavior in a specific situation. Habit evidence is admissible to prove that a person acted in accordance with a habit or an organization acted with a routine on a particular occasion.
So this is about a very specific, repeated, almost automatic response to a situation.
Exactly. Semi-automatic, reflexive, and crucially, habit evidence is admissible without corroboration and without an eyewitness. If you establish the habit, it can come in to suggest conduct on the day in question.
Wow, that's powerful. So how do you distinguish habit from character, especially on an exam?
Specificity and regularity are key. Habit is more specific than character. Look for keywords. Habit often uses words like always, every time, invariably, automatically. Sarah always locks her car door. The company routinely sends invoices on the first of the month.
Okay.
Character uses words like often, frequently, usually, or describes general traits. Sarah is often careful. Alex is frequently punctual. Habit is about a specific response to a specific stimulus. Character is a general disposition.
So if Alex always took a specific, unusual route home at precisely 6 p.m., that's habit, admissible to show he was likely there. But if he was just often in that neighborhood, that's more like character and probably inadmissible propensity. The always or invariably is key.
That's the core distinction to look for.
All right, let's move on to the witnesses themselves. Who can actually testify? Competence, Rule 601.
Right. Before anyone can testify, they must be competent. The general requirements are pretty minimal, actually. A person is competent if they have personal knowledge of the matter they're testifying about.
Saw it, heard it, experienced it firsthand.
Exactly. And they give an oath or affirmation to testify truthfully. They have to understand the duty to tell the truth.
So who is incompetent?
Generally, only someone who is unable to understand the requirement to tell the truth, maybe a very young child or someone with a severe cognitive impairment. But it's a low bar. Importantly, don't confuse competency with credibility.
Oh, right. Explain that difference again.
Questions about a witness's mental state, memory issues, maybe the effect of drugs or alcohol at the time they perceived the event, or how certain they are, those generally go to credibility, which is for the jury to weigh. They don't usually make the witness incompetent to testify altogether.
So if a witness in Alex's case was drunk when they saw the assault, they can still testify, they're competent, but the jury decides how much to believe them. Credibility.
Precisely. Competency is about the basic ability to observe, recall, and narrate under oath. Credibility is about how believable that narration is.
What about judges and jurors testifying? Seems problematic.
Extremely problematic. The presiding judge is absolutely barred from testifying as a witness at the trial they are presiding over. Rule 605, clear conflict of interest.
Makes sense. What about jurors? Rule 606.
A juror can testify, but only under very limited circumstances and outside the presence of other jurors. This is about protecting the secrecy of deliberations while addressing external problems.
Okay, when can a juror testify?
They can testify about extraneous prejudicial information improperly brought to the jury's attention, like that newspaper article about Alex slipped into the jury room, or improper outside influence, like a bribe attempt or threat, or a mistake on the verdict form, like a clerical error.
So things coming from outside the deliberation room or objective mistakes?
Exactly. What they cannot testify about is anything related to the internal deliberations, any statement made during deliberations, any incident that occurred, or the effect of anything on any juror's mind or vote. The mental processes, the arguments, the influences within the jury room, that's all off limits.
Protecting the black box of jury deliberations, unless something external compromises it.
Yeah, that's the idea.
What about dead man statutes? I know these aren't in the FRE, but they come up.
Right. These are state law rules, but they're important because federal courts apply state privilege law, which dead man statutes often function like in cases governed by state law, like diversity cases.
Okay. What's their purpose?
To protect a decedent's estate from potentially fraudulent claims by parties who have a financial interest. The idea is to prevent someone from testifying about a conversation or transaction with the deceased person when the deceased person can no longer refute it.
So someone claiming the deceased promised me his vintage car can't testify about that conversation if it harms the estate.
Generally, yes, if they have a financial interest in the outcome and the testimony is adverse to the estate. The specific rules vary by state, but the key takeaway is FRE doesn't have this rule, but it can apply in federal court via state law in diversity cases. It's about fairness when one side of the conversation can no longer speak.
A classic Erie doctrine issue. Got it.
All right.
Let's unpack impeachment more fully. Rules 607 through 613. This is all about attacking a witness's credibility.
Exactly. And remember, any party can impeach any witness, even the party who called them. Rule 607. It's not necessarily about proving they're lying, but providing reasons why the jury might doubt their testimony.
What are the main ways, the grounds for impeachment?
Generally, you can challenge a witness based on their character for untruthfulness. Rule 608. Their bias or interest, a reason to favor one side. Rule 607 implicitly allows this. Their ability to perceive or testify accurately, sensory defects, intoxication, or prior contradictory statements, Rule 613.
Okay, let's focus on character for truthfulness first. Rule 608.
Right. You generally cannot bolster a witness's truthful character unless it has first been attacked.
Can't prop them up preemptively.
Correct. If their truthful character is attacked, you can rehabilitate them, but only with reputation or opinion testimony about their truthfulness, not specific instances of honesty.
Okay. What about using specific acts related to truthfulness?
Rule 608B is key here. Specific instances of a witness's conduct offered to prove their character for truthfulness or untruthfulness are generally not admissible. You can't bring in extrinsic evidence of past lies or truthful acts just to show character.
But there's an exception on cross-examination.
Yes. On cross-examination, you may ask the witness about specific instances of their own conduct if those instances are probative of their character for truthfulness or untruthfulness. For example, asking a witness if they lied on a past job application.
Okay.
You can also ask them about specific conduct relevant to the truthfulness of another witness, if the witness being cross-examined testified about that other witness's character. But remember the rule. If the witness denies the specific act on cross, you cannot prove it with extrinsic evidence. You're stuck with their answer.
No mini trials on whether they really lied on that job application.
Exactly. And remember, an arrest alone cannot be used for this purpose. It's not proof of untruthful conduct.
Now, impeachment using criminal convictions. Rule 609. This seemed really complex earlier.
It is, and highly tested. Let's break it down again by type of crime and witness. First, any crime involving dishonesty or false statement, like perjury, fraud, embezzlement, whether felony or misdemeanor. These are always admissible to impeach any witness, subject only to the 10-year time limit. No balancing test needed under Rule 609A2. The nature of the crime speaks directly to truthfulness.
So automatic admission if it's a crime of dishonesty and not too old?
Pretty much. Second, felonies not involving dishonesty or false statement. Here, Rule 609 applies, and it depends on the witness. If the witness is not the criminal defendant, the felony conviction is admissible. Subject to the Rule 403 balancing test, it comes in unless its probative value is substantially outweighed by prejudice, confusion, etc. The balance favors admission.
Oh.
But if the witness is the criminal defendant, like Alex, the standard flips. The felony conviction is admissible only if its probative value outweighs its prejudicial effect to the defendant. Some circuits might say substantially outweighs. Either way, the burden is on the prosecution to show the probative value outweighs the prejudice. It's harder to admit against the defendant.
More protection for the defendant from prejudice based on past crimes unrelated to honesty.
Exactly. Finally, the 10-year rule. Rule 609B. If more than 10 years have passed since the conviction or release from confinement, whichever is later, the conviction is generally inadmissible.
Generally.
It can be admitted only if its probative value substantially outweighs its prejudicial effect. A very tough standard favoring exclusion. And the proponent gives reasonable written notice to the opponent. Very hard to get these old convictions in.
That conviction rule is definitely intricate. Depends on the crime, the witness, and the timing. What about prior inconsistent statements, PIS, Rule 613, showing the witness said something different before?
A very common impeachment technique. Any prior statement inconsistent with current testimony can be used to impeach. The inconsistency doesn't have to be a direct contradiction.
Okay. Do you have to show the statement to the witness first?
You don't necessarily have to show it to them before asking about it, but Rule 613B generally requires that before extrinsic evidence, like the document itself or another witness, can be admitted, the witness must be given an opportunity to explain or deny the statement, and the opposing party must have an opportunity to question the witness about it.
So confront them, give them a chance to explain fairness again.
Right. Though this doesn't apply if you're impeaching a hearsay declarant who isn't there, or if the PIS is also an opposing party's statement.
And the crucial distinction, impeachment versus substantive evidence.
Yes. Any PIS can be used for impeachment to show lack of credibility. But for a PIS to be used as substantive evidence to prove the truth of what was said before, it must have been made under penalty of perjury at a prior trial, hearing, deposition, or other proceeding, and the declarant must be testifying now and subject to cross about it. That's the non-hearsay exclusion under Rule 801D1.
What about impeaching someone who isn't testifying live? A hearsay declarant, Rule 806.
If a hearsay statement is admitted, the credibility of the out-of-court declarant can be attacked and then supported by any evidence that would be admissible if the declarant had testified live. You can use their prior convictions, inconsistent statements, evidence of bias, etc., just as if they were on the stand.
And rehabilitation. If a witness gets impeached, how does the lawyer who called them try to fix it?
Several ways. On redirect examination, they can ask questions to allow the witness to explain or clarify things brought up on cross.
Okay.
If the witness's character for truthfulness was attacked, the lawyer can now offer reputation or opinion testimony supporting their truthfulness. Bolstering is now allowed. And importantly, they can offer a prior consistent statement, PCS, but only under specific circumstances, to rebut a charge that the witness fabricated testimony or acted from an improper motive or influence. And the key, again, is the PCS must have been made before the motive to fabricate arose. Rule 801, B mon B.
The timing is everything for those prior consistent statements. It has to predate the reason to lie.
Got it. Okay, let's clarify present recollection refreshed. Rule 612 versus past recollection recorded, Rule 8035. They sound similar, but are very different tools.
Very different. Common point of confusion. Let's start with present recollection refreshed, PRF. This is simply using any item, a note, a photo, anything, to jog a witness's memory while they are testifying.
The memory jog.
Right. The witness once knew the fact but can't fully recall it now. The item helps them remember. Crucially, the witness then testifies from their refreshed memory, not by reading the item. The item itself does not become evidence unless the adverse party offers it.
And the adverse party gets to see it.
Oh, yes. The opposing party has the right to inspect the item, cross-examine the witness about it, and introduce relevant portions into evidence. This prevents abuse.
Okay, now past recollection recorded peers. This is a hearsay exception. Correct. This is used when refreshing doesn't work. The witness still cannot recall the fact, even after looking at the record. PRR allows the record itself to be read into evidence as a substitute for the witness's memory.
Because the memory is gone, but the record was accurate when made.
Exactly. The conditions are: witness once knew but now can't recall. Witness made or adopted the record when the matter was fresh in their memory. The record accurately reflects their knowledge at that time.
And how does it get presented?
If admitted, the record may be read into evidence, but it can be received as an exhibit only if offered by an adverse party. The proponent doesn't get to give the jury the document itself.
So PRF memory jog, item isn't evidence, unless opponent offers. PRR memory gone, record is evidence. Read in, not usually an exhibit for proponent. That distinction is crucial.
Absolutely critical for the bar exam.
Moving on to opinion testimony. Rule 701 and 702. Lay versus expert opinions.
Right. Let's start with lay witness opinions. Rule 701. A non-expert can offer opinion testimony if it's opinions. 1. Rationally based on their own perception, what they saw, heard, etc.
Like speed, emotions, intoxication.
Exactly. 2. Helpful to the jury in understanding the testimony or determining a fact. And 3. Not based on scientific, technical, or other specialized knowledge. That's the dividing line.
So, Alex seemed angry is okay, lay opinion. Alex suffers from intermittent explosive disorder is not.
Perfect distinction. The second requires specialized knowledge, which brings us to expert witnesses.
Rule 702.
Okay, experts, they need special qualifications.
Yes. Qualify by knowledge, skill, experience, training, or education. Their testimony is admissible if their specialized knowledge will help the trier of fact. The testimony is based on sufficient facts or data. It's the product of reliable principles and methods, and the expert has reliably applied those principles and methods to the facts of the case.
This is the Daubert standard, essentially, making sure the science is sound and applied correctly.
It incorporates the core Daubert principles, yes.
Wow.
The judge acts as a gatekeeper to ensure reliability.
Can experts base opinions on inadmissible evidence, like hearsay? They can, Rule 703, if experts in their particular field would reasonably rely on those kinds of facts or data in forming an opinion on the subject. Think of a doctor relying on hospital charts containing nurses' notes.
Okay. But does the jury hear about that inadmissible basis?
Usually not directly. The proponent may disclose the underlying inadmissible facts only if their probative value in helping the jury evaluate the opinion substantially outweighs their prejudicial effect. Another balancing act.
Got it. And how certain must the expert be? Can they opine on the ultimate issue?
They need a reasonable degree of certainty for their opinion. They can opine on an ultimate issue in most cases, Rule 704A, like, in my opinion, the defendant's actions caused the victim's injury.
But there's a big exception in criminal cases.
Huge exception, Rule 704B. An expert cannot state an opinion about whether a criminal defendant had the requisite mental state constituting an element of the crime charged or a defense thereto. Did Alex intend to cause serious harm? That ultimate mental state question is strictly for the jury.
Preserving the jury's role on the core culpability question. What about paying witnesses? Rule. Ethical concern.
Both. Lawyers cannot offer payment that's in excess of reasonable expenses incurred. travel, lost wages, or that's contingent on the testimony content or case outcome.
So cover costs, but don't buy testimony.
Exactly. The